Ang pagbili ng lupa ay hindi madaling gawain. Ang proseso ay hindi lamang titigil kapag nagbayad ka ng pera at nakagawa ka na ng deed of absolute sale. Isa sa mga pinakamahalaga na hakbang ay ang paglilipat ng pangalan sa titulo ng lupain mula sa pangalan ng nagbebenta sa pangalan ng mamimili, which is you. Ang pagkuha ng isang bagong titulo ng lupa ay ang tunay na katibayan ng pagmamay-ari mo sa lupa. After all, you can't call it yours if it's not under your name, right? And don't take this for granted. Failure to comply would mean facing technical, legal, and financial issues. What are the processes in buying a land in the Philippines? How much does it cost to transfer a land title? Welcome to our channel. This is Attorney J&J Law Made Easy. This video is made possible with the help and contribution of my very own geodetic engineer, Engineer Joyme. This video is for informational and educational purposes only. It does not constitute legal advice and does not establish any kind of attorney-client relationship. Furthermore, the discussion in this video is for general situations. Additional requirements may be necessary, and process may vary depending on the uniqueness or complexity of your situation. What to expect? A. Discussion on the steps and tips on the process in buying a land. How to investigate and verify the authenticity and authority of seller. What is notarized deed of absolute sale or transfer documents. 3. Securing certificate authorizing registration before the BIR. 4. Payment of transfer tax and transfer fees. 5. Submission of the requirements before the registration of deeds. B. Discussion on the following legal terms, particularly 1. Mirror doctrine and its exceptions. 2. Capital gains tax. 3. Documentary stamp tax. 4. Real property tax. Let's start with our discussion. Step 1. Verify the authority and capacity of the seller to sell the land. Check to be sure that the owner you are buying from has the title to the land. Undoubtedly, this step is very important. However, the question is, how? Paano? How to verify the seller's authority? Applying the mirror doctrine, a buyer may just check the certificate of title. First, to make sure that the title is authentic, the buyer may check the certificate of title from the seller and may also request a copy of certified true copy of the title from the Register of Deeds. Here, the buyer will need the title number and the name of the registered owner. Second, verify if the title is clean, meaning it is free from mortgages and any other encumbrances. Check the back portion of the title. In mirror doctrine, purchaser may be considered a purchaser in good faith when he has examined at least the latest certificate of title. Consistently, the court has ruled that every person dealing with registered land may safely rely on the correctness of that certificate of title issued therefore, and the law will in no way oblige him to go beyond the certificate to determine the condition of the property. However, this rule is not absolute. Exceptions 1. When a person deals with registered land through someone who is not a registered owner, he is expected to look behind the certificate of title and examine all the factual circumstances in order to determine if the vendor has the capacity to transfer any interest in the land. He has the duty to ascertain the identity of the person with whom he is dealing and the latter's legal authority to convey. Hence, the law requires a higher degree of prudence from one who buys from a person who is not a registered owner, although the land subject of the transaction is registered. While one who buys from the registered owner does not need to look behind the certificate of title, one who buys from the one who is not the registered owner is expected to examine not only the certificate of title, but all the factual circumstances necessary for him to determine if there are any faults in the title of the transferor or in his capacity to transfer the land. The strength of the buyer's inquiry and the seller's capacity or legal authority to sell depends on the proof of capacity of the seller. If the proof of capacity consists of the special power of attorney duly notarized, mere inspection of the face of such public document, the special power of attorney, already constitutes sufficient inquiry. If no such special power of attorney is provided, or there is one but there appear flaws in its notarial acknowledgment, mere inspection of the document will not do. The buyer must show that his investigation went beyond the document and into the circumstances of its execution. Another exception to the mere doctrine is when the party has actual knowledge of facts and circumstances that would impel a reasonable cautious man to make such inquiry, or when the buyer has knowledge of a defect or the lack of title in his vendor, or of sufficient facts to induce a reasonable prudent man to inquire into the status of the title of the property. The rule on reliance on the certificate of title is likewise not applicable in case of banking institutions. Judicial notice can be taken of the uniform practice of banks to investigate, examine, and assess the real estate offered as security for the application of a loan. We cannot overemphasize the fact that the bank cannot barefacedly argue that simply because the title or titles offered as security were clean of any encumbrances or lien, that it was thereby relieved of taking any other step to verify the overreaching implications should the subdivision be auctioned on foreclosure. Another exception is in case of financing institutions. In the case of GSIS versus De La Merced, the court has ruled that an investment and financing corporation is presumed to be experienced in its business. Ascertainment of the status and condition of properties offered to it as security for the loans it extends must be a standard and indispensable part of its operations. So that's all about the mirror doctrine and its exceptions. Let's proceed with the other tips and advice. Next, confirm that the yearly real estate tax are paid. As a buyer, it would also be prudent to check the tax declaration in order to confirm that real estate tax and payments are up to date. Real property tax is a kind of tax levied by the local government on properties and should be paid by property owners. Properties that are taxable include land, building, improvements on the land and or the building, and machinery. For now, the real property tax rate is 0.5% of 1% of the land assessed value. 2. Make sure that the land described on the title is really the land that you are buying. Here, it is also advisable if the buyer can validate with Register of Deeds or better hire land surveyor or genetic engineer to verify exact location. Remember, land titles don't have street names and number to pinpoint the property. It is a must to confirm that the actual property you are buying matches the technical description on the certificate of title. This is actually to avoid situations wherein, after going through the process of paying and having the title transferred into the buyer's name, only to find out later on that the land that he expects to buy is actually not the land that was described in the title. And note, this happens in a real scenario. Last but not the least, make sure the seller are the real owners. Here you may ask for identification papers. Before we proceed with the next step, I would like to bring your attention to the case of Domingo Realty versus CA, where the Supreme Court had the occasion to give a precaution to prospective buyers of title lands to wit. It is advisable that such parties 1. Verify the origin, history, authenticity, and validity of the title with the Office of the Register of Deeds and the Land Registration Authority. 2. Engage the services of a competent and reliable genetic engineer to verify the boundary, metes, and bounds of the lot subject of said title based on the technical description in the said title and the approved survey plan in the Land Management Bureau. 3. Conduct an actual ocular inspection of the lot. 4. Inquire from the owners and possessors of adjoining lots with respect to the true and legal ownership of the lot. 5. Put up signs that said lot is being purchased, leased, or encumbered. And 6. Undertake such other measures to make the general public aware that said lot will be subject to alienation, lease, or encumbrance by the parties. After you have found the land that you desire, agreed with the price with the seller, investigate and verify the authority of the seller, you are now ready for the next step: deed of absolute sale or transfer documents and notarization. Understanding the documents in real estate processing is a vital step in preparing to buy or sell a property. It is important to fully comprehend these documents before signing in order to execute the transactions correctly and avoid costly mistakes in the future. What is deed of absolute sale or transfer documents? Simply put, an absolute sale or transfer document is a legal document stating that one party is transferring his real estate property rights to another. This means that all the seller's rights to the property have now been passed on to the buyer. The buyer has now full right to use the property he purchased. The document is signed by both parties in front of a notary public. To be valid, it must indicate the date and location of the filing, proper identification of the property, and the name and address of the buyer and the seller. What if the seller or buyer couldn't sign in person? The buyer couldn't be present to sign the document. As in the case of overseas Filipino workers, the buyer may appoint an attorney-in-fact, which must be legally appointed through a notarized special power of attorney. What is the significance of the absolute deed of sale? This public document shows the legal transfer of real estate property ownership. Aside from being proof of the purchase, a notarized absolute deed of sale is among the required documents by the Bureau of Internal Revenue in order to transfer the land title documents in the name of the seller to the buyer. Without a notarized deed of sale, the taxes cannot be paid and the transfer of title cannot take effect. Take note also that the date of notarization is the starting point of tax liabilities. And lastly, these will also be submitted to the Registry of Deeds as well to be officially recorded. Step 3. Secure certificate authorizing registration. In order to secure certificate authorizing registration before the Bureau of Internal Revenue, you must first pay the capital gains tax and the documentary stamp tax. Capital gains tax is a tax imposed on the gains presumed to have been realized by the seller from the sale, exchange, or other disposition of capital assets located in the Philippines. The tax rate for real property is 6% based on the higher amount between the gross selling price, which is reflected in the deed of absolute sale, zonal value or the fair market value, which is usually found at the back of the tax declaration. Note, whichever is higher. The capital gains tax return shall be filed and paid within 30 days following the sale, exchange, or disposition of real property, with any authorized agent, bank, or revenue collection officer of the Revenue District Office having jurisdiction over the place where the property being transferred is located. Now, what about documentary stamp tax? The documentary stamp tax is an excise tax levied on documents, instruments, loan agreements, and papers evidencing the acceptance, assignment, sale, or transfer of an obligation, rights, or property incident thereto. This is about 1.5%. Note, these are just the two major expenses before the BIR. There may still be minor or small fees associated with these steps. Once you have secured the certificate authorizing registration, you may now proceed to the step 4, pay the transfer fee on property and transfer tax. Again, with certificate authorizing registration in your possession, you now need to pay the transfer fees and tax before the Provincial Treasurer's Office. A transfer tax is a tax on the passing of title to property from one person or entity to another. In a narrow legal sense, a transfer tax is essentially a transaction fee imposed on the transfer of title to property. Lastly, Step 5. Register of Deeds. You are now almost ready to get your title. Register of Deeds will have some requirements you need to submit and satisfy depending on your situation. Affidavit of publication and the owner's copy. The Department of Agrarian Reform clearance if land is agricultural, approved subdivision plan if the land is part of subdivision, Affidavit to nationality if not a citizen of the Philippines. Question: how much does it cost to transfer a land title? Apart from the price of the property, there are also fees and taxes that need to be covered to complete the transaction, which includes capital gains tax, equivalent to 6% of the selling price on the deed of sale, the zonal value or the market value, whichever is higher, unpaid real estate taxes due, if any, the commission of the agent or broker, if any, but is usually 5%. Documentary stamp tax. This is commonly set at 1.5% of the selling price or its zonal value or fair market value, depending on which is higher. Transfer tax. Local Treasurer's Office. This tax is imposed at the rate of 50% of 1%, 75% of 1% in the case of cities and municipalities within Metro Manila. CTC on real property, 1 peso for every 1,000. Registration fee, commonly set at 0.25% of the selling price or zonal value or fair market value, depending on which is higher. Notarial fee, depending on the amount of the selling price of the land, this usually varies from 1% to 5%. Incidental and miscellaneous expenses incurred during the registration process. Hence, the total of these taxes and fees is the cost of transferring a land title which, as mentioned, depends on the overall value of the land or property being transferred.
Thank you for watching patiently. If you like this video, please like and click that subscribe button. And please feel free to comment down below, we will be happy to reply as soon as possible. We hope to see you again in our next video.